one that is most relevant for our purposes today is that which is provided under federal law, specifically in 19 U.S.C. 1307. And that definition is the following. Forced labor shall mean all work or service which is exacted from any person under the menace of any penalty for its non-performance and for which the worker does not offer himself voluntarily. So two key elements there. Number one, the lack of voluntariness. This is something you don't want to do. And number two, the menace of penalty. So theoretically, if someone wants you to do something that you don't want to do, but there's no penalty associated with that, then that potentially might not be forced labor. But those are the two key elements. It's important to note that this prohibition under 19 U.S.C. 1307 extends to convict labor. Convict labor is not included as forced labor. It is sort of classified separately, but for practical purposes, goods that have been made using convict labor will be treated in the same way that goods made using forced labor will be treated. And just in case anyone is wondering, the law stipulates that child labor is also considered forced labor, or more specifically, forced child labor is also problematic under the law. Good to know that that's the case, of course. Two important developments in recent years that have changed the landscape for forced labor. Number one, the US got rid of what was known as the consumptive demand exception, which basically provided a loophole allowing the importation of goods made using forced labor if we were not producing enough domestically. That loophole has been closed. And number two, as revelations regarding the extensive use of forced labor in China, specifically in the context of or in Xinjiang, in the Xinjiang region, as those revelations came out, that coincided with a bad moment in US-China relations, and therefore the forced labor issue became entangled with US-China relations, and by extension with internal politics here in the United States.
The first part, as Fred mentioned, is the original law that goes back to 1930. Section 307 of the Tariff Act of 1930, also codified at 19 U.S.C. 1307. As Fred also mentioned, the consumptive demand clause operated in that law in such a way as to preclude its effective active enforcement over the many years that it's been on the book. That changed in 2016 with the Trade Facilitation and Trade Enforcement Act, TIF-TIA, which repealed the consumptive demand clause and opened up the door to CBP using the companion regulations, which have been on the books for some time, I believe since the 60s, 19 CFR 12.42-45, to use the mechanisms that are built into those regulations to begin to enforce forced labor in a way that had not taken place over all those years. The companion regs basically provide for a withhold release order. CBP is empowered upon a prior investigation to issue a WRO, and that WRO can eventually evolve to what's called a finding. If there's a WRO in place with respect to merchandise, CBP will detain merchandise, and at that point, an importer has the opportunity to challenge that detention within a defined period of time, or export the merchandise if they can't prove that there's no taint of forced labor. Between 2016 and 2022, that was kind of the state of the art until the UFLPA, the Uyghur Forced Labor Prevention Act, was enacted in December of 2021 and went into force in 1 year ago today. The UFLPA supersedes the foregoing, at least with respect to subject matter merchandise that comes within the UFLPA. And the UFLPA basically creates a presumption that merchandise either made within the Xinjiang Uyghur Autonomous Region, the XUAR, or by an entity on the UFLPA entity list is made with forced labor and therefore prohibited from being entered into the United States and released. Like the companion regs, there are detention procedures, and an importer has the opportunity to challenge those detentions. It's a very short period of time for doing so. And basically, there are two challenges. One is an out of scope challenge, which is basically saying my merchandise is not within the scope of the UFLPA. And the other one is a challenge that is acknowledges the fact that the merchandise is in scope, but nonetheless falls within an exception. The evidentiary standard for overcoming that detention is clear and convincing evidence, and it's a challenge. It's not a lot of time to respond to these things, and importers are well advised to have their have done their due diligence up front, so that if and when the time comes, they're ready to provide CBP with the information they need.
The reality is that in most cases, it will not be possible for CBP or frankly anyone here in the United States to know for sure what is happening. However, as Bob just explained, in the context of goods originating from Xinjiang or made at by entities that are on that entity list, then there's a rebuttable presumption that they were made using forced labor. Beyond that, we know that CBP will take information from different sources, including whistleblower reports. There are mechanisms for parties to submit allegations anonymously to CBP. So in principle, there could be information that is being received from potential customers of these facilities that are going there, by workers, by NGOs, et cetera. In addition, there are organizations that are looking closely at this issue. For example, Sheffield Hallam University in the UK, the Australian Strategic Policy Institute, and these organizations deploy considerable resources toward figuring out what's going on when, for example, a facility is identified as being essentially a re-education center in Xinjiang. If there are factories located close by, then of course that's a red flag that there might be something going on, right? If a factory is within walking distance of a place where we know Uyghurs and others from Xinjiang are being quote unquote re-educated, and that of course is it's a very important data point. In addition, there have been advances in terms of tracking manifests and other shipping information to try to establish patterns. So for example, where one problematic actor is identified, then the technology can be deployed to try to assess if there are links to any other entities. So going forward, we can expect technology to be leveraged increasingly in terms of trying to find which facilities are engaging in these practices.
There are a number of things that an importer can do to guard against forced labor detentions, and in a nutshell, it boils down to doing due diligence. And in this regard, CBP and the FLETF, the Forced Labor Enforcement Task Force, have fleshed out pretty comprehensive guidance documents which provide importers with guidance on supply chain due diligence, tracing, and management practices. In terms of the most important due diligence steps that an importer can take, there are a number of them. For one thing, you're going to want to begin by reviewing the guidance documents I just mentioned. Two, you're going to want to conduct verification visits if at all possible to the facility. That doesn't mean that you'll get access to the employment records and the employees, but you're going to want to have made that effort and be able to explain that to CBP if and when the time comes. Three, you're going to want to integrate forced labor provisions into all relevant transaction documents. Four, You're going to request that producers, exporters, your suppliers complete questionnaires and certifications of no forced labor, which will become part of the package of documents which are submitted in conjunction with an entry. You're going to want to obtain and analyze bills of material, which have information about who the supplier is, the name, the address, the zip code. You're going to want to conduct supply chain mapping. There are a number of service providers out there which will do this as a service for a fee. We can provide you that information if you need it. You're going to want to screen the UFLPA entity list, just as you would in an export context. It's a list that you're going to screen it and make sure that the people that appear on your BOM are not appearing on that list. You're going to want to commission an independent third-party audit, if possible. This has become something that's become trickier over time. Might not be possible at this point, but it is identified as something that importers can do. You're going to want to consider pursuing a CBP ruling, getting CBP's blessing in terms of how they would view the transaction as structured with the information that you can present to demonstrate that there's no taint up the supply chain. And then finally, you're going to want to engage with the CEE that's relevant to your particular harmonized tariff schedule code. They'll have product-specific guidance they can offer as well.
One of them concerns a lack of cooperation from suppliers, and this might be due to any number of reasons. In some cases, there might be a somewhat legitimate concern with the release of proprietary information. In some cases, there might not be a real understanding of why this information is being requested. Also, and this might be a little bit difficult for folks who are not engaged in manufacturing to understand, sometimes your supplier in a place like China might have very limited visibility into its own suppliers, right? All it cares about is obtaining the materials it needs to manufacture products. It may not be engaging in extensive due diligence as to what's happening at that supplier or at that supplier's suppliers. Also, it is important to keep in mind that suppliers in China are concerned about the possibility of retaliation. There are, in fact, laws that have been passed targeted at cooperation between different parties and foreign governments, such as the U.S. government, in trying to enforce their own laws with regard to these activities in China. Even beyond that, obviously, when you're talking about programs that have been established with governmental sanction, for a factory, a company in China to say, well, we're going to help this effort by a foreign company to make sure that we're not actually participating in that program. I mean, it's not hard to see why suppliers in China might not be thrilled to be participating in these efforts. Beyond that, it's also important to understand that companies in China might be not only willing participants, but might actually be proud to participate in these forced labor programs. Obviously, they're looking at them through a different lens, but without going into the history of Xinjiang, which is of course outside the remit of this program, it is a complex relationship, and for Chinese, it has there are different ways in which they look at this. Also, again, for those who don't operate in the world of manufacturing, it might seem surprising that facilities are not keeping certain kinds of information, but remember, the mission of these facilities is to produce goods. It's not to keep records. And if a particular kind of record is not deemed essential to their to their ultimate task of producing goods that they can sell, they might not bother keeping them, right? So it's also important to understand that. And to underscore something that Bob just said, even though in principle audits, third-party audits might be a good way of gaining visibility into what's happening, finding reliable auditors is getting tougher. Part of it is the fear of retaliation that these auditors might face. Part of it might be that they're simply unable to obtain the access that they need to make reliable determinations. So in sum, challenges are plentiful.